ॐ असतो मा सद्गमय तमसो मा ज्योतिर्गमय मृत्युर्मा अमृतं गमय ॐ शान्ति शान्ति शान्तिः Om. We pranam to all of you. Today is the second day of our IKS-TKDL workshop on traditional knowledge, intellectual property, and people's rights. Today, Sir Anil Sir with us. He will talk about the fundamentals of intellectual property rights. Before we start the session, we just want to repeat about the guidelines. Please complete the assessment after the session. So we have a 50-minute session which will be followed by a short assessment period, that is 10 minutes. You will have 5 MCQs to complete within 10 minutes. Then we'll go to the next part, that is question and answer session. And if you face any problem to join, because there is a limitation in WebEx, so only first 1,000 participants can join. Others are encouraged to watch our YouTube live and access the assessment link from your Google Drive folder which you have received. Astu. So, sir has experience of law and prosecution. Sir is the senior scientist of TKDL unit. Sir is responsible regarding traditional knowledge prosecution. Sir has degree of biotechnology, management, and business law. So, sir will talk about different types of intellectual properties like copyright, patents, then industrial designs, GI. So, I request sir, please start your session. Please check your mic, sir.
Am I audible?
Yes. Now
So I'm
it's
just sharing my presentation. Okay. Is it
yes.
visible, Yoshi?
Yes, it's visible.
And it is in full mode?
Yes. Perfect.
Yes, and they are moving also.
Yes.
So good afternoon, all the participants. So this is the 7th CSIR TKDL and IKS division workshop on traditional knowledge, intellectual property, and people's right. So basically, it is from 1st to 7th of April that we discussed yesterday also, and every day we have 1.5 hour session, which includes question answers and assessment also, a small assessment. So we are into the second day of this workshop, wherein today we are going to discuss about the fundamentals of intellectual property rights. So basically today we are going to discuss the current scenario of IP rights which exist. And we'll also discuss some case studies. So this session will be of 50 minutes followed by 30 minutes question answer and a small quiz, as Piyushi has already explained. So when we talk about the intellectual property rights system, it basically talks about the recognition of intellectual creations and preventing them, uh, preventing their unauthorized use. So it basically talks about the recognition, protection, and securing fair return of investment on the intellectual creations being made. So when we talk about recognition of creations, so these intellectual creations, they can be literary works, they can be inventions, they can be different kind of no items being created by the skill of an intellectual, which requires protection under different national legal statutes. So when we talk about these national legal statutes being used for protecting these intellectual creations, we must understand two things. First, these legal statutes, they are judicial specific, and they are basically applicable in a limited area. So when we talk about the Patents Act of 1970, which is the patent law, governs inventions in India. It is governing the patents in India only, and the effect of that law is within the jurisdiction of India. So in case you want to have a patent, you want to get a patent in US, you have to approach the regulatory authority of US for getting the patent, and the laws of that that country, US, will be applicable. So all these laws which govern these intellectual property creations and their protection, they are jurisdiction specific. Okay. So this thing we must understand. So when to get further into the system that we are discussing, so when we create something which is having a value, a creation out of our intellect, it has to be protected, because the unauthorized use of that creation will demotivate the creator or the author, and it will not help to promote the technological advancement of the domain area. So when these intellectual creations are protected through legal statutes, in a way they give a limited right to the author or the creator to use those creations as per their wish for a limited period of time. So for example, if we talk about patents, the rights granted under patents are for 20 years. So the person or the author who has secured the rights, he can exploit that invention for a limited period of 20 years in that country and secure fair return on investment. So while he's securing rights over that intellectual creation, he has to disclose that invention fully. Okay, so it's a kind of disclosure to be made to the public. So once that term of that intellectual property vanishes, then that intellectual creation comes into the public domain, and anybody who is having an interest can exploit that uh, invention for further development or for the benefit of the society. So this is the system that we follow. And when we talk about the intellectual property rights, the kind of rights that we have, so these intellectual creations, they are basically governed by various statutes, and the subject domain are copyrights, patents, trademark, industrial designs, geographical indications, and plant variety varieties. So we'll be going one by one and discussing all these tools in detail in future and in for the slides. Okay, so the first kind of tool that we are going to discuss is the patents. So when we talk about patents, the patents are granted for inventions. And when we talk about inventions, basically the inventions, they can be, an invention can be a product or a process. So when we talk about a product or process which qualifies to be an invention, then they must they must deliver a solution to the existing problem. Okay. So when we talk about an invention which is related to transportation, then that invention must address a kind of problem which existed for a longer time, and there was a unmet need to address that issue, and the person solving that issue or providing a solution to that problem, be it a product or a process, can get a patent over it. And when we talk about the purpose of the patent, the ultimate purpose of the patent is to promote technological innovations, and it can be done in two ways. Basically, when we talk about technological innovation, then one way of promoting technological innovation is like the person who has invented that, who has given that invention, must get a fair commercial reward over that invention for a limited period of time for 20 years, and he can get a premium over the product which he has. And another thing that we can talk about is like the documentation and publication of the technological information. Okay, so when we file a patent application, it's a legal requirement that we must submit the complete specifications of that invention. So it means that we have to submit a specification providing details of how that invention has been made and how that invention can be used. Okay, with some specific examples. The motive of this documentation or disclosure is to make a person understand the invention, and after the expiration of the duration of the term patent, it should be workable by others and it should come into public domain. So these were this was the purpose of having a patent. But if we talk about the requirements of a patent, then there are certain requirements which, the first requirement of getting a patent is like it must be novel. So when we talk about novelty of a patent, it means that that invention must not have been disclosed prior to the date of application. In case that invention was existing in public domain, or there was a disclosure of that invention, then it doesn't qualify to be a novel thing. Okay, so it must not have been disclosed in public domain prior to the date of filing. It must be inventive in its origin. That means that a person having ordinary skill in that inventive domain that invention should not be obvious to that person. Okay, so there must be intellectual activity being, intellectual skill being employed to arrive at that invention, which should be beyond the natural working of that person. Okay, the third category, the requirement under to get a patent is the industrial applicability. So the product or a process for which a patent application has been filed must be capable of being produced in industry. So this is the industrial requirement, the applicability of that invention industrially. So in case you fulfill all these three requirements, you can get a patent, provided that the invention, the subject domain of that invention is falling under patentable subject matter. Okay. So to give you an example, if we see this cycle, which is having a roving mechanism. So this patent was granted in the year 1900. Okay. So at that point of time, this mechanism was not disclosed in the public domain. So that qualified to be novel at that time. Correct. It means that on 30th January 1900, this invention was novel enough because it was not disclosed on the date of application. Okay. And moreover, if we talk about the inventive step, uh, we know that roving mechanism is used for boats and other sailing things, but bicycle works on the pedals. But somehow they have they have applied their intellectual skill to arrive at a bicycle, which is having a roving mechanism. However, the invention has a combination of two elements, one from the bicycle and one from the boat. But combining those features are beyond the capability of a normal skilled person. So in a way, it has overcome the objection of obviousness. But we are talking about in the year of 1900. But if you talk about this invention at present date, then it is certainly an obvious thing because the state of art in that technological domain has developed. And we know that it is very obvious to combine these two features at present date. So on the date of application, that is on the 30th January 1900, it was granted. But if we file a similar kind of patent, it will not be novel and it will not also overcome the non-obviousness objection. Likewise, if we see the bottle opener, this was granted in the year 1939. It was novel enough at that time and it was having inventive step. But if we talk about the present day, technological advancements being done and made in the domain, it is obvious and it also lacks novelty. So this was a kind of arrangement we have for patents. So if we talk about the patentable subject matter, so if we have already seen that in case there is a new product or process having inventive step in which is capable of industrial application is patentable, but it should not fall within the objections in section 3 and section 4 of the Patents Act. So what are these objections? So these are the certain items which are excluded from being patentable in India. Okay. So if you talk about the section 3, it talks about the frivolous inventions. So something which is against the natural, something, if we say that we have a machine which works on 100% efficiency, we all know that in science it is not possible. So such kind of inventions which is prima facie frivolous in their existence, they can't be patentable. Okay. Likewise, if we see something, an invention which is against or contrary to the public order, or which is against the morality, and which may cause a serious prejudice to the health or human or a plant life, then those things are also not patentable. Okay. So if you see section 3C, it talks about the scientific principles being discovered. So in case we discover something which is a principle governing the life, or governing the natural phenomena, that those things are also not patentable. So those are discoveries rather than inventions. So discovering something doesn't qualify to be an invention and those are not granted. Likewise, if we see section 3D, it says discovery of a new form of known substance or new use of known substances, they are also not patentable. Likewise, section 3E, it talks about the admixtures leading to aggregation of properties. So wherein, I mean, there is a mixture of two compositions which merely leads to aggregation of the properties of the two elements being combined, two compositions being combined, then that will not qualify to be an invention. Okay, and it will not be patented as per Indian law. Likewise, the mere aggregation or duplication of devices, devices where the working of those devices is known, and we have just combined two devices, those things are not patentable. For example, if we talk about a fan which is having a light in the middle, so we have just combined the properties of a fan with the light. Okay, so those kind of arrangements are not patentable. Okay, in under section 3F. Likewise, the methods of agriculture or horticulture, they are also not patentable in India. So, and the methods of surgical, curative, prophylactic, diagnostic, therapeutic process or processes for treatment of human animals, those are also not patentable. Apart from that, plants and animals in whole or any part of, plant or animal seeds other than microorganisms are patentable, are not patentable. Okay. So the microorganisms are with certain human interventions qualifies to be patentable. However, plants and animals in a whole, they are not patentable. And if we talk about mathematical business, uh, mathematical methods or business methods or software, those things are also not patentable under Indian Patent Act. Okay. And the copyrightable subject matters, which the items which falls under designs, the domain of design registration, they are also not protected because we have a separate law governing the copyright and design protected items. Scheme or method of mental act, playing games, those are also not patentable. Presentation of information is not patentable in India. Then those integrated circuits, they are excluded from being patented in India because we have a separate sui generis law on protection of integrated circuits in India. And most importantly, in case something which is in a way traditional, which is in fact is a traditional knowledge, or it is mere aggregation of known properties of a traditionally known component, is not patentable in India. So something which has been developed on the traditional knowledge, and it is in effect is a kind of a product being developed, that those things are not patentable in India. Apart from that, atomic energy inventions, these inventions are not patentable under Section 4 of India. So if we summarize, the subject matter of patents, then an invention, be it a product or process, is patentable, wherein it is having an inventive step and is capable of being produced industrially. And those things can be apparatus, devices, machines, as given in this slide. They can be chemicals, they can be medicines, they can be food, their compositions, even biological processes wherein the human intervention has been, done to change the pathways, or similar kind of activities wherein there is a substantial human activity, then those things are patentable. Then we have certain biological products which are patentable, and we have certain processes that can be patentable in India. Okay. So now the another thing, the next tool that we'll be discussing under the intellectual property rights system is copyright. So basically, copyrights, they protect a wide range of literary, artistic, and scientific creations. Okay, so when we talk about literary creations, those they may include poems, story, novels, plays, reports, and artistic. Likewise, artistic items may include paintings, sculptures, photographs, or drawings. And when we talk about scientific creations, they may include softwares. So softwares are basically their copyrightable subject matters. And they also, the copyright also protects the dramatical and musical compositions apart from cinematographic films and sound recordings. So basically, if we talk about copyright, it protects the expression of ideas. Okay. It doesn't protect the idea as it is. So the only requirement of protection under copyright is the subject matter of copyright, be it a literary, artistic, or scientific creation, should have been expressed on a tangible form. Okay. So it's a legal requirement. Until or unless you don't express it on a tangible form, it can't get protection. And the best part of getting a copyright is like the moment you express it on a tangible form, be it a paper or or any other material, you get the protection suo motu. Okay. In certain jurisdictions, it gives a suo motu protection. There is no need of getting a registration. However, there have been options available for getting a copyright registered before the copyright board. Okay. So the moment you create, you get a right in it. So if we talk about the essential requirements of a copyright, it has to be original in nature. Okay. So when we talk about the originality in copyrighted works, it has to be it has to be new. It has to be original in its expression. It must not be copied from somewhere. Okay. And in case there is a kind of motivation from an existing work, then there must be a substantial dissimilarity between the two works. They should not be similar in their expression. And the test of originality is like a person who is reading who is reading the two literary works should not come to a conclusion that both are copied. Okay, so it's a kind of test which is employed, and the originality has to be there for literary, dramatic, musical, and artistic works. Okay, and when we talk about the cinematographic films, basically they are combination of these four items. They may be a combination of these four items, and those four items which forms the cinematographic film should be original in their expression. Okay, so when we talk about a cinematographic film, it must have a, story, which is a literary work and should be original in nature. It may have a musical composition, which is falling under musical work, and it has to be original in nature. However, the combination of different elements may create another copyrightable subject matter, which is protected under cinematographic films. Likewise, sound recordings, they may not, they may be a combination of original works falling under these green categories. So this was the whole scenario and the layout of how copyrightable subject matter and the system works. When we talk about the rights of the owner, so the person having copyright, he has a right to reproduce his work in different forms. So if we talk about a literary work, he can have a printed publications, or when we talk about sound recordings, he can have a reproduction of his sound recordings. The person having the copyright in its material can have, has the right to distribute the copies of the work, and he may also authorize the public performance of that work. It also has the broadcasting and other communication rights in it, and he may also, control the translation of the work. Okay, and apart from that, he has also a right to control the adaptation of the work. So adaptation is like turning a novel into a screenplay. So when we talk about a novel and making a film out of it, it's a kind of adaptation that we are making to that work. So when we get we have a copyright over a novel, then the adaptation of that novel into a movie is also protected. So the rights that are governed under the copyright is like the person having the rights is having basically these rights fall under three categories. First is economical right, wherein the person has the financial rights. He can just license it out. He can assign it to somebody. He can, get revenue out of the copyrighted work. So those assignments can be, in full, or they can be jurisdiction specific. It depends on the work and the author. So he has an economical right to gain revenue on his own copyrighted works. The other kind of right that exists in copyrighted works is like its moral rights. So when we talk about the moral rights, those rights contain the right to get attributed as the author of that work. So when you transfer your economical rights, so basically these moral rights, they remain with the author until or unless you have an explicit kind of assignment. So once you transfer the economic rights, these moral rights of getting attributed as the author, and to prevent the distorted reproduction of the work lies with these moral rights. Okay. And apart from that, in case somebody is performing in a movie, so that performer has certain rights to perform those uh, works again. So it's a limited right, however, but it is there in the law. So if we talk about the remedies for infringement of copyright, So there are civil remedies wherein we can get injunctions, we can stop the infringing party, we can get damages, we can get the cost. Apart from that, I mean, there are certain acts which are criminal in action, I mean, criminal in nature. So the police can take cognizance directly, and there are provisions for imprisonment, and there is a provision for fine also. And there are certain administrative measures to prevent the infringement of copyright items. So the next tool that we are going to discuss are the trademarks. So in daily life, we came across certain marks which are being used by the companies or the producers or the service providers to differentiate their services from others. So when we talk about trademarks, basically these are simply marks which are capable of being represented graphically. So if we talk about the M of this McDonald's, so it's a mark being used by a specific no outlet to identify its products. Okay, so this M can be represented graphically. That means it must be visible to others. So it's a requirement in India, but we have seen that certain invisible marks are also registered across the globe. So sound marks, they are also being registered across the globe. And the fragrances, these are the invisible kind of marks which have been registered. Okay, but the majority of the in majority of the cases, these marks should be visible enough, and they must be represented graphically to get registration. So these marks are basically distinctive, and they indicate the provider, be it a manufacturer or a service provider. So basically, it's a consumer-centric law wherein the producer or a service provider uses these marks to identify its services, but the consumer, he can link the reputation of that producer or service provider by looking at that mark. Okay, so these are basically marketing and branding tools being used across the globe, and they may contain words, designs, signs, symbols, shapes of goods, packaging, color, or combination thereof. So these are some of the examples which we see. I mean, these are additional marks. And if we talk about the term of protection of trademarks, so basically the initial registration is given for 10 years from the date of application, which can be renewed further for additional 10 years. So it's like, in case you want to use it, you can renew it after every 10 years. And when you are not interested or you want to just drop it, you can stop renewing it. It will get lapsed. Okay. And it's a tradable asset. You can license it, sold it to the other parties partially or completely to gain additional revenue. So this is one of the examples wherein traditional knowledge came into play. So basically, if we talk about, I mean, these Taita baskets. So these are, I mean, these are the baskets being woven in Taveta County of Kenya. So it's an age-old skill wherein the sisal plants, the fibers from sisal plants, it's agave cisalana, which, I mean, these fibers are being used for production of some specific baskets. Okay. And the kind, I mean, the processing of these fibers to get the fibers out of the plant, it's a very, traditional method being employed for ages. And the kind of weaving these, I mean, these are being made by the women of certain communities there. So it's a traditional art which they do. And the art of weaving has been transferred from one generation to other, and it has been kept intact. So the whole challenge before this community was to get a branding, no, a brand for these baskets, so that they can be identified differently and they can be distinguished from the similar goods in the market. So the WIPO, with some funds from Japan, I mean, they worked on the problem, and they got this mark registered as a collective mark. So if you see this orange mark wherein this Taita basket is written, it's a collective mark which is owned by a group of people, an association which is responsible for the benefit of the viewers. I mean, it is, and the best part of this mark is like all the viewers, they must comply to certain given quality standards. So they got a brand, and they also specified certain quality standards of those baskets, which helped to gain immense customer confidence and recognition. And it also helped in preserving the traditional knowledge. So it's an example wherein trademarks were being used for branding a product which is having a traditional knowledge element in it. So the next kind of intellectual tool that we are going to discuss is industrial designs. So if we talk about industrial designs, these are basically the aesthetic or ornamental aspects of a product. So if we see the different shapes of the bottles that have been given on the right top, so we see that those shapes are different from each other, and these different aesthetic appearances can be registered as industrial designs. So it's basically a feel, a look and feel kind of element. It has nothing to do with the functionality. In case the shape is having some kind of functional element in it, those things are not registered under industrial designs. So these are basically the physical appearance or look and feel elements which are protected. And when we talk about the relevant aspects, then shapes, configurations, surface patterns, ornamentation, composition of lines or colors, which can be applied to an article by any industrial process or a manual or a chemical process, is can qualify to be registered under industrial designs. Okay, and it is limited to the visual appeal of the article only. So there is nothing linked to the functionality. Okay, and the design must be original in its application for, I mean, to qualify as a registrable design. Okay, and when we talk about the originality with respect to the industrial designs, it talks about that it should not include, I mean, it should be originating from the author of such designs. It should be new, and in case it is applied to a different item, then that application should also be new. Okay, so these are the requirements under the industrial designs registration, and these are the items which cannot be registered under industrial designs. Okay, so as we discussed, the in case there is something which is inherent in an article, if we talk about a watch, so the physical appearance of a watch can be registered under industrial design, but in case there is an article within that watch which can't be visible from outside, so and it is also having some kind of visual appeal, but that is not visible from the finished article, then those things are not patent, they're not registered under industrial designs. In that case, I mean, it has to be the outer appearance of the watch that is registrable, not the invisible part, which, I mean, the part which is inside the watch. Likewise, if you see the buildings and structures, those are excluded from registration. Part of an article that can't be sold separately, those are also excluded from being registered. The variations which are commonly used in trade are also not capable of being registered. Then stamps, labels, tokens, medals, trademarks, cards, cartoons, those things are also not registered. More importantly, emblems and flags of nations, they are also excluded. And in case we have a miniature or enlarged model of a known design, that is also not registrable under industrial designs. Likewise, computer chip, integrated circuits, those are also excluded. If we talk about the duration of the protection which is granted under industrial designs, is the initial registration is given for 10 years, which can be extended by another 5 years. So the maximum protection that is available under this law is for 15 years, subject to renewable for 5 years after 10, initially 10 years. So the next tool that is there available under intellectual property rights system is geographical indications. So basically, we all know that geographical indications, these are the signs which are basically used for products. And the unique thing which is linked to these geographical indications is like that these products where, I mean, which are indicated with specific GIs, they have certain specific geographical origin, and they possess certain qualities and reputation, and these qualities and reputations, they are linked to the specific geographical origin which is there. So the best example where we can discuss is the Darjeeling tea. Okay, so when we talk about Darjeeling tea, the tea is originating from a geographical location within the Darjeeling. Okay, and there is a specific quality in that tea, the aroma, the kind of taste it gives, which is linked to the geographical location, the agroclimatic conditions there. Okay, and if you talk about the Darjeeling tea, apart from the agroclimatic conditions existing in that area, it also has a human factor involved. So the way it is being it is processed there, it has a human factor involved. Okay, so it qualifies to be a GI wherein both natural factor and human factors are involved in making that product. We all know that, I mean, the dazzling tea is a premium product and it commands certain kind of, additional value in terms of money. So therefore, I mean, these GI products, they are potentially valuable. And I mean, these marks can be used to identify, I mean, specific goods. Okay. So if you talk about the duration, it is basically initially registered for 10 years, which can be further renewed for 10 years, and you can continue renewing it till you intend to use it. Okay. It cannot be assigned on license like we have talked about the patents, copyright and trademarks, because it is a collective right. So the applicant should be an association working for the benefit of the producers or manufacturers of those products, and the person, I mean the people, they have to register as a registered user. Okay, so there is no concept of assigning or licensing the GIs. And the information of registered GIs can be accessed from the IP India website, which is given in this slide. Okay, so if we talk about the classification of geographical indications, basically they are, I mean, falling under three categories: agricultural, natural, and manufactured goods. And these are some of the examples wherein, I mean, the Darjeeling tea, Guntur chili, and raw turmeric. These are the agricultural items. And if we talk about naturally occurring, geographical GI products, then red sandstone and other items given in the slides, then these are the registered GIs. And if you talk about manufactured goods, they comprises of handicrafts, manufactured industrial goods, and food stuff. These are some of the examples. So as I discussed, that these are the essential key attributes for geographical indications. So there must be a geographical area. Okay, it means that the product should originate from a particular area, or in case it is being processed there, then at least one stage of processing should have happened in that defined area. And you have to provide a defined map of the territory or the locality from where it is originating. Another thing, it is like the reputation of the product. So that product must have a specific nature. Okay, in terms of reputation, we can say that it has a specific quality, or I mean, it must have also established repute. And this reputation must be linked to the product originating in that geographical area. So we'll share the slide. You can go through the specific elements afterwards also. So if we talk about the examples, so this is one of the examples wherein two states, I mean, they applied for a similar kind of product. One was the Rasgulla of Bengal. It's Banglar Rasgulla, and Odisha Rasgulla. So West Bengal and Odisha, they applied for getting their products registered as GI before the GI registry, and it was found, although it was a conflicting, no, these were the conflicting applications, but it was found that both the products, although were similar in nature, but they had different characteristics. So they were different. I mean, they had a different color. So if you talk about the Bangla Rasgulla, it was white in color as compared to the light brown color of Odisha Rasgulla. So it was considered that in view of these differentiations existing in these two products, and we all know that these two products are characteristically different, existing in two different geographical locations. So these both the applications were given registration. So as of now, is Bangla Rasgulla and Odisha Rasgulla, they both are registered as separate GIs. Okay, so initially it was a dispute, but finally they both got registration for their respective products. So another example that we can take is of Varli paintings. These paintings are being practiced traditionally in the area of Konkan region near Mumbai. Okay, so basically these are the paintings which are practiced on mud walls, and the paste which is being used and the brushes being used for making these paintings are also traditionally made. So these brushes are made up of bamboo sticks. They just chew them out and make a paintbrush. Okay. And the paste that is being used for making these paintings, they comprises of rice water and gum, and they are made traditionally. So the art of making these paintings is also passed from one generation to another. Basically, it's a kind of, these are being made during certain occasions like marriage or other rituals, wherein the members of the society, they sing some songs. So the oral songs being, I mean, sung by the members, and the stories being told, they are the motives of the painting. So it's like somebody is singing something, and other members are making those paintings on the walls. So it's a kind of folk art being practiced, and it is a unique mix of traditional cultural expressions and traditional knowledge. But an application was filed for registration of worldly art under class 16, 20, and 25. So originally these applications are, I mean, these paintings are made on the walls, but the application which was filed, it comprises of the application of these paintings on paper, notebooks, wood, and canvases. So it's a kind of traditional art being used on different materials. So it's a connect between the traditional knowledge being practiced and the contemporary application. So then the tool that we have is about the plant variety protection. So if we talk about new varieties, so in certain jurisdictions like US, the plant varieties are patent protected, but we have a sui generis law in India, and we have this Protection of Plant Varieties and Farmers' Right Act, which was enacted in 2001, and it is being governed by UPO. It's an international agency which takes care of the uniformity of law across the countries. Although we are not signatory to UPO, but we have enacted a law which is aligning to the requirements of UPO, and it has some additional features. So these additional features includes the rights of farmers. So apart from breeders' right, we also have recognized farmers' right in our country, which is a UPO plus model. So the requirements of getting a new variety registered is distinctiveness, uniformity, and stability. So it's like the new variety must have some distinct characteristics, okay? And they must be uniform in their expression, and they must be stable across the generations. So these are the three requirements under which are essentially required for getting a plant variety registered. So if you talk about the kind of varieties which are capable of being registered, we have new varieties. Okay, so these new varieties, they have certain novel characteristics which are distinct from others, having uniformity in their expression and stability across the generations. Likewise, we have extant varieties, we have farmers varieties, and essentially dried varieties. So the criteria of registration is given in this table. The rights conferred is also there, and duration. So we'll share this slide, which will give you a proper understanding about the basic uh, criteria and the durations granted for registration. The another unique tool that is available is the circuit and layout design of semiconductors. Okay, so there is a unique law in India which protects the layout designs of semiconductor circuits. Okay, so it protects the basically, I mean, these are the chips that we see. So if you see this back of the laptop, it has certain circuitry elements. Okay, and these circuitry elements are embedded on a chip wherein they are connected through lead wires. So the layout of these circuitry elements having through these wires, it also has it also requires certain kind of intellectual skill. That's the reason we had this specific law protecting these elements. So we see these kind of circuitry elements in electronic items such as watches, televisions, and all kind of equipment that we use in daily life. They have these elements, and making these these products smaller requires a certain degree of intellectual creation. So that's the reason we have this law. And if we talk, the definition given for this layout designs is, it's an outline describing the semiconductor integrated circuit having transistors and other circuitry elements connected with read wires. Okay, So basically the protection is given to the map which is there. The map as you can see on this slide. Okay. So the requirement of registration is like that the layout that you are submitting for registration should be inherently distinctive. That means it must be inherently different from others. It must have its own identity as compared to others, and it must not be similar to the existing ones. Okay. So it must be capable of distinguishing itself from the existing maps. Okay. And if we talk about the bar, in case it's not original, it lacks some, the intellectual effort, or it is commonly known previously, then it is not registrable. Moreover, in case that layout design was known or it was being exploited commercially globally 2 years before the date of application, then also it is not protected under this specific law. Okay. And in case we are combining two or more layouts and coming up with a new layout, which is different from the existing two, then it also qualifies for being registered under this law. And the duration is 10 years from the date of application or first commercial use. Okay. So if we summarize different types of IPs that we have discussed, so this is the table which give you a fair idea of what is protected under which tool. So if we talk about literary, musical or artistic works, definitely those are copyrightable subject matters and they are protected under copyright law. Okay. Likewise, if we talk about vaccines, drugs, which are inventions, and the process of making those vaccines and drugs, those are patentable matters and they are protected under patent law. Likewise, if we are using certain kind of marks like Coca-Cola to identify our products or certain kind of marks for identifying our services, then those are protected under trademarks. So trademarks can be of certification mark or collective marks, as we discussed in the case of those baskets. Then there is a specific law, geographical indications, which talks about the protection of marks being used on products having certain geographical origin and a reputation linked to that origin. Then we have we talked about industrial designs, the design which are basically having aesthetic look, nature. There is nothing attached to the functionality of those products. And we also talked about layout of integrated circuits and plant varieties. So if we talk about the similarity and differences across these tools being discussed today, so there are certain conceptual similarities in all these tools. So basically, they protect the product or processes made out of the creative intellectual activity. They have a criteria for protection also. They confer exclusive rights wherein the owner of those rights can exclude others. He can have a kind of exclusive ownership for a certain period of time. There are certain limitations and exceptions, and the kind of protection is given, it's limited in time. So these are the conceptual similarities and difference. If you talk about the differences, then the subject matter of each tool is different. So inventions are protected under patent law. Then literary, dramatic, and artistic works, they are protected under copyright law. So each tool has a different subject matter. Okay, and they have different requirements also. So for being a patentable, for an invention to be patented, it must have novelty, must have inventive step. And if you talk about the trademarks, they should be capable of graphical expression. And if we talk about copyright and industrial designs, they must be original in their application. So those are the requirements. Okay, and there are certain conditions for protection of each tool that we have discussed, and those nature of rights are also different. Okay, and if you talk about the duration, patent laws are for 20 years, copyright is for 60 years after the death of the author, starting from the next year, from the first day of the next year. And if we talk about trademark law, it's 10 years, which can be further renewed 10 years. So the duration of the protection is completely different. It depends on the nature of the product. So to summarize, we must say that IPR, they protect the intellectual creativity and inventions. And if we talk about patents, design, copyrights, basically these are recognizing the intellectual skill and the inputs, and they give a commercial reward over the efforts being made. And if we talk about trademarks and GIs, basically these are consumer-centric laws, wherein the consumer can differentiate between a particular good or services, and they can be used as branding tools. and they can be the computing feature also. So if you talk about these intellectual property creations, these ideas can be converted into assets because you get a definite, I mean, a specific time duration to get a fair return on your investment. Okay, so this is a system wherein, I mean, proper care has been taken for the kind of investment required and the kind of, I mean, return one can have. Although those are, I mean, for certain specific divisions, depending on the nature of the IP. And these tools, they protect and boost innovation. They can protect businesses, and they are the competent, I mean, they provide edge while you talk about the growth of the businesses, and it talks about the branding and financial security of the products. So this was all about the IP tools. So they, I hope that all the participants, they got a fair understanding of the system of intellectual property rights. Thank you.
Yes. Thank you very much, sir, for delivering this informative session. So, sir, please allow me 10 minutes to complete the assessment, then we can start the question and answer session.
Sure,
Astu?
sure.
Yes. So, we are posting a link here in the chat box. Please, there are 5 MCQs. Please complete as soon as possible. You have 10 minutes to complete your assessment. I'm sharing link in the chat box as well in the Google folder I have uploaded. Namaste. 2 minutes left. Please submit your assessment. Time up. Namaste, Pranam Arya. Arya has joined. Arya, you are muted. Could you please unmute and say something before we start?
Energy and all this course. Can you hear me, Piyushi?
Yes.
Piyushi, can
Yes.
you hear me? Okay,
Yes.
okay.
Uttam.
Okay. Yes. So I sincerely hope that the participants have been able to complete the assignment, the assessment.
So we
Yes.
can move forward the question and answer session. So we request all the participants, please, you can type your questions or you can raise your digital hand. We will unmute. So there is a question someone asked, sir, if you suggest some journals on IPR regarding, is there any recommendation for
Yes,
journal?
there is a question on reputable journals on intellectual property rights.
Yeah.
So in this regard, I would like to submit that CSIR one of the laboratories of CSIR, that is National Institute of Science Communication Policy Research, NISPER, they are having Journal of Intellectual Property Rights, which was started in 1966. So that is one of the reputable journal which can be referred to.
Even WIPO, they keep providing for a lot of reading material and also
Reading
regular
materials.
training and workshop. So whoever is specifically interested in IPR matters can also refer to the WIPO site. So, hi.
Piyushi,
So
you
there
are.
was a question. I saw there was a question about the trademark. How much time does it take to register a trademark?
If you talk about registration of trademarks, so it depends on the nature of the mark. Okay. So in case it is quite unique and it is not similar to the existing ones, you can get the trademark very easily. I mean, the duration is very short. But in case it is similar to an existing mark, then you will have you will receive objections from the office first. So you have to just submit a written submission saying that these are my submissions and if they are not similar, in case the office is satisfied, they will process it further, or else you will get an opportunity of being heard. So there will be a hearing fixed. So it depends on the process and the steps which are involved. Okay. So
Anilji,
starting from few
Anilji,
months to
sorry.
few years, I mean, it may take.
Anilji, the question by Dr. Abid Sultan was more specifically says, how much time does it take to register a brand under a trademark?
Yes,
Under
yes,
trademark.
it differs. It differs. So starting from a month, it may go for years also. So in case there is no objection, it will directly accepted and it will be published in the journal and you will get a certificate in after 4 months.
So very
In case there is
typically
no
that we would, so very typically that whoever wants to register a brand would have to apply for it. Where would they apply for this? In the
So they have to apply before the trademark registry.
okay, and that application comes with a fee. There would be a
Yes,
fee for the application.
yes, yes. There is a
Is
fee
that a
attached to it.
one-time fee or is that a continuous fee that you have to pay?
So it's a continuous fee. So at the time of filing that application, you have to pay the filing fee. And once it is registered, you have to pay the renewal fee every 10 years.
Acha, but then every 10 months?
10 years.
Every 10 years, okay.
Every
And
10
this
years.
initial fee, does it depend on the product or is it a standard fee? And how much is it, just for general knowledge?
It's a standard fee depending on the nature of the applicant. So there are individual categories. There are categories for companies. In case you are a startup or a MSME, there is a different, rebate in the fee. So the
Okay,
differentiation
okay.
is on the nature of applicants,
Okay.
irrespective of the product or a process. I mean, the nature of products.
Just for general knowledge, can you tell us what is the range of a fee, like just for?
So if I'm correct, I mean, it's like 4,500 if you file an online application and the nature of applicant is individual. In case it's a corporate, a company or a government organization like us, CSIR, then it is 10,000. And if you file online, there is a 10% rebate. So it's 9,000 per application.
Yeah, Dr. Abidji, if you had any specific thing in mind that you could maybe ask, there was, let me see, there was a question just before that on the basmati. So this is Dr. Makarand Ghare, who's saying basmati rice, has it been successfully registered by India in the US?
Yes. So basically, as I told, these IP laws, they are jurisdiction specific. Okay. So in case, I hope he is talking about trademarks or GI. He has not clarified. So
Okay, so Dr. Makaranji, can you please clarify, because this is basmati rice, has it been successfully registered by India in the US? Because at some point there was this rumor or move that you would be aware of, possibly of US trying to patent basmati rice and a few others. Indian products. So was there some?
So meanwhile, I mean, there is another question that we can take up. This is like,
Okay.
this is from Mr. Ashwini. So the question is how to secure architectural designs. So basically architectural designs, if we see, they are artistic in nature. Okay. So the laws which can be applicable are two. One is copyright law and one is design law. But we have seen that in design law, it is completely the aesthetic view and it bars the architectural designs from being registered. So if you see the dominance of the law which comes into play is the copyright law. And section 2B of copyright law, it clearly defines the architectural designs. So it means that architectural designs are copyrightable subject matters. You can register these designs under copyright law. However, certain elements of architectural designs can be registered under design law also. Okay, but as such, in case it's architectural design, that cannot be protected under design.
Anilji, yes. Usually we can't hear you if you're saying something.
Now, yes,
We
one
can.
question from Dr. Mohanji. If we are picking up any writing of a poet which is more than 50 years old and use it for broadcasting, will it be considered as a violation of copyright?
Sir, the duration, first we have to see that the duration of the copyrighted material. So as I told, the duration of copyright protection is 60 years after the life of the author. Okay. And the right starts from the first day of the next year when the author dies. So it's a very long time. So you are saying that 50 years old, I mean, you have to identify the author first, the owner of the copyright. Okay. So in case he is alive, you have to seek the permission. Okay. In case he is not alive, you have to wait for 60 years. So in both scenarios, this 50-year doesn't work.
Thank you, Anilji. There's one by Anil Gaikwad ji. So he's saying, what is the process for obtaining design patent through WIPO? And how can we extend the validity of obtained patents beyond 20 years in India? Please guide.
See, when we talk about the WIPO as a platform for filing patent applications, one thing we must understand that the patent is granted by the regulatory authorities of the respective country. So at WIPO, you can file a patent application. Certain of the steps are being taken at WIPO, and then those applications are transferred to the national, the states, the countries. And the later on those processes, I mean, after a stage, those processes are taken up by the respective country, which you have designated or opted for, and they will just examine those applications in detail and grant applications. So WIPO doesn't grant patents. It provides a mechanism to file patent applications, but patents are granted by the respective countries. I hope I have answered the first portion of the question. The second portion was like increasing the validity of a patent in India. That's not possible in India. So it's a definite term, 20 years. Once that is finished, you can't extend the validity of a patent. And that's the nature of the law also. After a certain period of time, the duration, it has to come to the public domain. So there is no
Is this the
possibility
same in
of
other
extension.
countries? Anilji, do the other countries also have this kind of a time limitation or a duration within which you have to make it public knowledge?
See, I mean, duration is specific in all the countries, but extension is possible in few jurisdictions like US. So they have certain provisions for specific products only, pharmaceutical products, subject to certain fulfillment of conditions. So
Anilji, I just have a question, like little off this, but very relevant in today's context. So in today's context of AI and access to a lot of information through various sources. What happens if one accesses maybe information like that, or how does one protect in such a scenario?
So when we talk about AI generated creations, so first we'll take the example of patents. So we have created a product using 3D printing. Okay. So basically it's a combination of human skill plus the AI tools. Okay. So one thing we must understand that we have to fulfill the basic essential requirements of getting a patent. Okay. So it has to be novel. It has to have it has to overcome the obviousness thing also, and it must have industrial application. Okay. So in case it fulfill all the requirements and it is not falling under the bar under section 3, you can get a patent. Okay. But in case we have a copyrighted material, okay, so we have generated a photograph using AI. So those things, there is a confusion still. Okay. So the applicant has to be a human. Okay. So these machines, they can't file for a copyright application. However, once it is published, the author will have certain kind of protection. But in case there is an objection stating that it has been created through AI and there is no intellectual input by the author, then certainly things will go apart. So we have few cases wherein those things were discussed and decided before the court. So one famous case was of Naruto, wherein a monkey, not AI, he took a picture. So the question was like, now who is the author of that photograph? So although the dispute was settled out of the court, it could not be decided legally. But yes, there are certain issues involving the ownership of IPs.
Just one other thing. Supposing you have a product, like if the idea is by one person or a group, and then the execution into maybe software or a product is by another, then who has the copyright of this overall product?
Ideally, it's a combination of the skills, then they both must be the applicant. It belongs to both. The quantum of work each has done has to be decided.
But if there is a dispute between these two, then who retains the copyright of the content?
See, the law that we follow in India is first to file. So once you go and file application, it will be processed in your name. But in case you oppose that, stating that I'm also the participant or the contributor, then the registry will take decision on the basis of the evidence being produced there before them.
Okay, okay. Here there's a question by Dr. Nanda Ji, who's saying that for any noble educational ideas, can there be a patent? If yes, what type of patent it is called? It is called, yeah.
So method of teaching, ideas, those things we can't get a patent. Okay. So in case you have an idea, you just write a novel, it will be a copyrighted subject matter. You will get a copyright over it. But in case you create a product, okay, out of that idea, that can be patented, provided it fulfill all the essential requirements like novelty, inventory step, industrial application, and out of the purview of section 3 and 4 of Patent Act. Then you can get a patent.
Same type of question from Sumita ji. Is skill development questionnaire patented or not? Any questionnaire skill?
It's a copyrightable subject matter because it's a literary work. So we have already seen the essential requirements of getting a patent. So we have to see whether that subject matter fulfill those conditions. So literary work is protected under copyright law and it has to be original. However, you have to fulfill all the conditions of copyright law. Also, originality is one of the basic ingredient, essential requirement.
Here we have another one in the context of education by the Usha Institute for Professional Education. It says in open AI education resources, how will we take IPR? Anilji, couldn't hear you.
Yes,
I don't know if
yes.
it's at my
Yes,
end.
yes. Getting a copyright protection over AI
This
generated.
is for open educational resources. How can we take IPR?
So basically, if we talk about the literary work, so those things can be protected under copyright. Okay. So as I told, copyright is can't, I mean, you get a copyright at the time of creation. So once you express that material on a tangible form in a book or somewhere, you get protection provided you mark it like, no, some, I mean, we see people using C in circle and they write the year of publication with their name. So it's a kind of, marking the document copyright protected. You just mention the year of its publication and the owner's name, the author's name. So this is one way of getting protection. So another way of getting protection is you just file an application before the copyright board for registration of those materials. So in that scenario, you will just submit your material before the board and you will get a certificate once it is registered. So it's a proof of, I mean, securing rights. So, however, it's optional. I mean, it's not mandatory, but still you can go for the second option.
Anilji, in line with some of the discussions that we've been having around, copyrights, patenting, and all for humanities subjects and sciences and all. So there's one by Dr. Isha Chowdhury who's saying that what kind of IPRs could there be in the field of psychology?
Psychology is like, if you talk about the literature, it is copyrighted, I mean, copyright protected. So in case you have written some kind of reading material, you can secure copyright over those materials. And if you talk about
If
psychology,
you do some inventive interventions, so if you have designed some interventions, so for example, in order to maybe create an intervention for calming the mind or for testing the intelligence or some scale, or these are the one is the scale production and what happens to that if I've made a scale to do an assessment of whatever
yes.
nature I want to do.
So in case
That
we are
is one.
talking
The
about
second is if I've
questionnaires,
designed an intervention.
so in case we are talking about questionnaires or some kind of test that we have developed, okay, those things are also copyright protected. But in case there is a technological outcome, we have developed a machine based on our outcomes, which can test. It's a kind of in case we have a diagnostic device being developed, those things can be protected under patents. So those are inventions. So these two things, I mean, they address psychological outcomes. I mean, the
Yes.
issues.
It's almost 5 o'clock, Arya. So I request you, please. Yeah, you can take last question and then we can end with Shanti Mantra.
Okay. Anilji, is there a question? If you having a look at it, is there something that you think is very important? Otherwise, I think we have the tradition of taking down some of the questions and later in time getting our experts to reply to them. So,
There is a question which says, can a work published be patented? What should be the order? So as I told, something which exists before the date of application, it kills the novelty of that application. So in case you have published your own findings, okay, and then you are going for filing a patent application, then your own publication will kill your novelty. So that's the reason it is said that you just file a patent application and then publish. So the date of application is the cutoff date. Those inventive concepts should not exist before the date of application, either as a product or a process being used or published in a material.
right. There's one, sorry, Piyushji, one IKS question which I have to ask. Okay. So it says, this is by Shiv Kumar ji, who's saying, it's an interesting one. So he says, according to history, some inventions are made by ancient Rishi Munis before 2000, 3000 years ago, which are copied by Britishers. So can you get a patent on all those inventions? So what happens to basically ancient material that finds modern expressions either through products or whichever way. So what happens in that context?
So basically, if we talk about inventions based on traditional knowledge, so in Indian law, section 3p, it says in case something is based on the traditional knowledge, or it is in fact the traditional knowledge or aggregation of the properties of traditionally known components, that is not patentable. So our Indian law, it specifically bars the inventions which are based on TK as such. Okay. Moreover, in case we say that those things were disclosed 3000, 4000 years back, then the information is already in public domain. Okay. So once you file a patent application and those findings which were published few thousand years back are accessible to the examiner, then that information will kill the novelty itself. So you have to be novel in terms of the invention. So in both scenarios, those patent applications are not granted. But yes, in case there is an incremental development over the findings that were published 1000 years back, then there is a question of examining those claims. And in case it is inventive enough, then patents can be granted.
Yes, thank you very much. I think there are these challenges of old wine in new bottles. So, things that are there, if novelty is a thing that you present it newly in a new format, then
Yes.
how does it work out? So yes, so I think there are lots of very interesting questions, but due to the shortage of time or time up, we will stop here. And Piyushi, over to you.
Yes, Astu. So thank you, sir, and thank you to all the participants to join with us. Although everybody has a busy schedule, so let's close today, and tomorrow we'll see at the same time. Tomorrow, Madam Dr. Vijayalakshmi Asthana, Madam, will talk about the ethical aspects of TK. Astu. So let's close with Shanti Mantra. Om Sarve Bhavantu Sukhinah Sarve Santu Niramayah Sarve Bhadrani Pashyantu Ma Kaschit Dukkha Bhag Bhavet. Om Shanti Shanti Shanti